Good morning, everyone. It is still morning. I'm Dean Reuter, Senior Vice President and General Counsel of the Federalist Society. I'm very pleased to welcome all of you here today. I'll start by apologizing for the delay in our start time. We, I think, are pretty famous for running a ship-shape set of conferences, and we almost always start and end on time, but there's some logistical issues that were beyond our control, frankly. But thank you for your indulgence, and welcome to our conference on Shareholder versus Stakeholder Debate. Special thanks to Charles Elson for his work in helping to organize this important conference. And I want to thank Nick Marr if he's in the room. Even if he's not in the room, I'll thank him for his organizational help, lining up speakers and handling logistics, et cetera, et cetera. Now, since you are here, I probably don't need to emphasize to you the great importance of shining a light on the many, many pressures now being exerted in society, on nearly every aspect of society, but as we'll be discussing today, particularly in the business world. Questions about the purpose or the primary purpose of a corporation have reemerged powerfully. Do corporations owe their primary allegiance to shareholders, to stakeholders? And if the latter, how are stakeholders defined and limited? If everyone is a stakeholder, is anyone a stakeholder? Would such a shift be a slight change of focus or a major recalibration of the way the business community acts? Either way, who gets the powerful role of deciding who qualifies as a stakeholder? These are some of the questions that are on my mind and I guess we'll be hearing about today. But before we get to those questions, we're going to begin with a panel looking at the historical antecedents of this important debate. With that, I'm very pleased to welcome the moderator of the first panel, Professor Charles Elson. His bio is in the materials available to you, so I'm going to stop my introduction there and turn it over to him with, again, special thanks for Charles for organizing the conference. Charles.
Thank you. Thank you very much, Steve. Well, I want to thank the Federalist Society for putting this together and agreeing to do this. It's interesting, the Federalist Society, I don't know if many of y'all know this, was one of the very first groups into the corporate governance discussion game. This was back in 1996. The Federalist Society organized a conference on the Caremark case that had just been decided. And Chancellor Allen was there and a number of others, the plaintiff's lawyer in the case. And it was a great discussion. And it was so good that we haven't done it again in 20 years because we had to wait for this topic to come around. But it was, it's a great topic discussed. And I think it really goes to the heart of what the Federalist Society does and thinks about. And the fact that you have a group of such differing opinions on the issue, I think makes it particularly special. I think the funniest thing at that first conference, there was someone there named Damon Silvers, I think some of you all may know, who's very active in the union movement. And he said, we asked him to comment on it, and he said, what am I doing at a Federalist Society meeting? I said, then you don't know the Federalist Society. That's exactly what you're doing. Everyone is, the idea is to have a debate amongst intelligent folks from both sides, or three sides, depending on the issue. Anyway, this is a particularly topical, obviously, conference, in that, if you note, in the last few years, the stakeholder-stockholder debate has reemerged. Thank goodness it continues. For law teachers, it's sort of it's a full employment act. Because I think we have been arguing about this at least ever since I've been in the business, and I know that the others on the panel probably feel the same way. It's an issue that we hope doesn't resolve, otherwise we won't have much to write about or narrow our writing. But obviously, we've seen it in the political side. You've seen bills introduced in Congress to effectively reintroduce stakeholder theory to the corporate area, to sort of take regulation away from the states and have effectively a federal stakeholder statute. And this discussion, even in the political sector from the President of the United States has made statements that, that the other stakes need to be more involved in the operation of the business itself. And it's really reopened this discussion that some people thought had been shut in the early 90s with the rise of shareholder primacy. And it was an academic discussion, but not necessarily a practical discussion. Today it's more practical. But we're going to take the academic side of the debate. It's a great panel to discuss this. Let me start to my immediate left, Professor Jill Fisch, who's the Fox Distinguished Professor of Business Law at the University of Pennsylvania I always say law school, but now it's Carey Law School.
I said law school too.
Yeah, thanks. Okay. Law school. Jill is actually one of the co-reporters for the ALI project on corporate restatement of corporate governance, and they've just come out with a draft on, guess what? Corporate purpose, stakeholder stuff. So I'm delighted that Jill can join us. We've known each other really since we've both been in teaching about the same time. So way back. And delighted. At one point, she came to Delaware, and she not only was a great panelist at the speech, but I had to get her back to the train station, and it started to snow, and coming from Tampa, I didn't know how to drive in the snow. I got her there alive, but only thanks to her instruction on how to navigate when you went down the hill, you know, in the snow. Anyway, sorry about that, Jill. But, seated next to Jill is Professor Yaron Nili, who's an associate professor of law and the Smith-Rowe faculty fellow in business law at the University of Wisconsin Law School. Yaron actually was going to be a doctor at one point, but I'm glad he chose the other kind of doctorate than the medical. Yaron is a terrific young scholar who has done a lot of writing, terrific writing in this particular area, and I've always admired his work, and I'm delighted he can be here with us. I thought he would add some punch to the discussion. See, the rest of us, Yaron, have been doing this a little long, and you need to sort of jazz us up a little bit. Seated next to Yaron is Professor Brett McDonnell from who is the Dorsey and Whitney Chair in Law, Business Law at the University of Minnesota Law School. Actually, no, it's simply Chair in Law, not Business Chair, though Dorsey and Whitney does a lot of business. Brett and I have discussed this topic for a long time, and it's fueled many debates, and I can tell you categorically, he and I completely disagree. However, it is really fun to argue with him about it. He takes, I think, a really intelligent, well-argued, well-conceived, wrong, of course, position on it. And I thought he would be terrific for this. And there are, a couple of those in the academy who talk about this stuff, and he is really, I think, one of the best. And so I'm delighted he can be here. And then, of course, saving Professor Bratton for last, you're Emeritus now. Oh, good. Nicholas Gallicchio, Professor of Law, Emeritus, because I was about to say, wait, he's not. He's at the University of Pennsylvania Law School and University of Pennsylvania Carey Law School. Bill has written about this debate for a long time. Bill is also an old friend of the biz. We started out kind of around the same time. Bill a little before me, and has been a long-time astute observer, not only of this stakeholder-stockholder debate, but really has done tremendous work on the history of the debate, on Berle, Means, and Dodd. And I thought the context he was going to provide for us and the, I think, sensible approach he's taken to this area would be terrific. And so I'm delighted he's here. Again, good friend. The nice thing about having on academic panels, if everyone's a good friend, the volume doesn't get too loud. So we'll keep it down. Anyway, introduce the topic, very straightforward. I mean, obviously today we're talking about should the purpose of the corporation be for the benefit of the shareholder, primarily, a la shareholder primacy, or should the fiduciary duties of directors run, in addition to shareholders, to the other stakes in the business? Is the purpose of the corporation to provide value to society or value to the investors themselves? And it's a great legal debate. It's reappeared. The origins of this debate, interestingly enough, came in 1932 in a series of exchanges between Merrick Dodd, at that point of Harvard Law School, and Adolf, Berle, and Gardner Means of Columbia. And with Dodd suggesting that as corporations have become creatures of society, that the obligations of those of the enterprises did not run merely to those who had invested in it in the rather distant past. This comes from his article, but to the other stakes. And of course, on the other side, Berle and Means said no. It should be shareholder primacy. And that debate went on and on and on until of course, in the end, Dodd did change his views later in his life, but that debate started this whole approach. And for years, as you know, Dodd kind of won, at least not in the legal sense, but in the popular sense. And companies, for many years, viewed themselves as having multiple obligations. It wasn't until the rise of the corporate governance movement in the early 90s that we began to see popular acceptance again of shareholder primacy, basically on the note of accountability, et cetera, et cetera. And of course, debate has shifted again, and here we are back to where we started. And for that, I'm going to turn to Bill to give us a bit of a history of this thing and sort of set the tone for our discussion, debate, or agreement festival, anyway, which I don't think we'll have. But go ahead, Bill.
All right, thank you, Charles. Let's see if I can be heard. I'm going to speak from a 2008 paper that I wrote with Michael Wachter, in which we challenged the historical picture that Charles just gave you that puts Berle in the position of great-grandfather to today's shareholder primacy and shows Dodd as the great-grandfather to today's corporate social responsibility or alternatively today's constituency-based firm. This is going to be the most 1932 you can get. Our reading works from a typology of 20th century political economy built around a distinction among pluralism, corporatism, and communism, which marks both Berle and Dodd as corporatists. Cutting to the chase, I'll contrast corporatism with pluralism. Pluralism is us. It looks to the preferences of individuals in calculating welfare for government policy. Outcomes are determined by competition for individual votes in a political marketplace. Interest groups are out there, but have no political status beyond the aggregation of the preferences of their members. Property rights rule. Corporatism accepts property rights too, but it also enfranchises groups, emphasizing cooperative relationships among the groups and between the groups and the state. Two principles dominate. First, there's an objectively cognizable public interest articulated by the government after consultation with the major groups. Second, once the public interest is expressed, the groups are expected to cooperate and support it. Property rights can yield at that point. Now, the term corporatism is avoided in this country due to links to European fascist regimes. But corporatism was also Latin America after World War II. It was, to some extent, Europe as well. See the German dual board. That's a corporatist institution. To a significant extent is China today. And it also was U.S. politics in 1932 and the first phase of the New Deal. Our paper makes two assertions. If you take this description of corporatism to the BerleDodd debate and to Berle's big book with Gardner Means, The Modern Corporation and Private Property, and read them in historical context, you can explain every line in all of this. Second, once you've done this, there's no basis for connecting Berle to shareholder primacy and not a whole lot of a basis for connecting either Berle or Dodd to modern CSR. It's a tricky case to make because Berle's papers shed no light on his academic work. As of 1932, there are only 6 pages of Berle's published work that support our read, and those pages can be read as CSR. Moreover, as of 32, the rest of published Berle does indeed admit of a read as shareholder primacy. We surmount these problems by watching Berle evolve over time. You go back to the 20s for the start, and you find Berle in a Wall Street law office writing articles about growing management power and what to do about it. He's a shareholder advocate and suggests several things. Self-organization by investment bankers, monitoring by investment institutions, and stricter stock exchange rules. There's an intriguing resemblance to today's contractarianism. But for present purposes, 2 points matter. First, Berle wrote off the courts as agents of reform, and he wasn't yet worrying about the corporation's role in the broader political economy. He began work on the book in 1928, hooking up with Means, who was an economics graduate student at Harvard. Means showed Berle that 200 corporations controlled 1/3 of the national wealth and predicted that by 1950, 200 corporations would control 70% of the national wealth, with considerable discretion regarding pricing. At that point, Berle started to change. He dropped his contractarian strategy and adjusted his view of the courts, emerging with his trust model of corporate law. Much of the book was devoted to that model. He took a chunk of that work and spun it out into Harvard Law Review in 1931. expanding on his published shareholder advocacy with 3 points. 1, managers were trustees for the shareholders. 2, managers might only exercise their wide-ranging discretion for the shareholders' rateable benefit. And 3, the judiciary should vigorously enforce the trust. Once this paper is published, another Berle starts to emerge, and that's Berle the public intellectual rather than Berle the corporate lawyer. Like many others at the time, he believed that free market capitalism was inherently dysfunctional and had brought the country to the brink of collapse. In early '32, he joined the Brains Trust of the FDR campaign. There, he was one of a faction that the historian Ellis Hawley would later term the planners. They advocated acceptance of concentrated industry, together with government economic planning, and fought against an opposing faction of Brandeisian liberals who favored market competition, trust busting, and small business. That September, FDR gave the planners the nod within the campaign and set out their views in what came to be called the Commonwealth Club speech, a speech that was written by Berle. The speech treated everyday management practice as a political problem. Ordinary citizens had a right to economic security, a right infringed by corporate managers, termed the princes of property. To address the problem, Berle pulled out his trust model, but substituted citizens for shareholders in the role of beneficiaries. Continued sufferance of management power depended on the citizen trust fulfillment. The princes had to assume responsibility for the public good, end their internecine disputes, come together as industrial groups, and cooperate toward a common end. Should any group defect from cooperation, the government would intervene with punishment. Thus coordinated, firms could adjust production to consumption and distribute wealth more equitably. The chaotic marketplace would be disciplined by an economic constitutional order. This is corporatist Berle expounding new themes that he would continue to expound for the rest of his life. It's no longer just corporate law issues, it's a national political economy with the same trust model being used in both contexts with different and apparently inconsistent ends. Now to the book, published in August 1932. This helps us bring these two Berles together, if not merge them into a coherent whole. The book continues the shareholder trust model, but sandwiches it inside opening and closing pieces that address the broader implications of management's social and economic power. Ownership and control had separated, empowering managers. Classical economic assumptions about owner control and responsibility no longer obtained. Standard individualist defenses against government intervention could no longer be countenanced. Indeed, we needed to cross the public-private divide and deem corporate property to be public property. Now, if corporate property was public property, then a question needed to be addressed. Was the corporation about social welfare, or, as the book's trust model implied, about shareholder welfare? The book finally took up this question in its last 6 pages. There, Berle redeployed the trust model for the citizen beneficiaries of the speech. Since shareholders had given up responsibility for corporate property, that's separation of ownership and control, other constituents should join them as beneficiaries. Passive shareholder property rights would give way to a system of community obligations centered on employee security and business stabilization. Management must develop into a, quote, purely neutral technocracy. There were no other specific instructions. Meanwhile, the book had 2 versions of the trust model, one for the citizens, one for the shareholders, hanging in mutual tension. There's the book. So let's watch Berle work on the galleys early in 1932. He's minding his own business when Dodd enters the picture in the Harvard Law Review in May 1932, slamming Berle's 1931 shareholder trust article from the left. Said Dodd, "The view that corporations exist for their shareholders makes no sense in the context of the present crisis. They should instead act as social institutions, providing economic security for their employees." He assured the reader that managers would undertake this trust in a responsible way, citing conservative business leaders like Owen Young and Gerald Swope at General Electric. Now, read out of context, this does indeed model a constituency-based firm under management control that's not a whole lot different than the Blair-Stout team production model of today. But it had a much more specific meaning at the time. In May 32, just about everybody thought the Democrats were going to be elected and there was going to be some kind of corporatist reform. The question was what that was going to look like. One of the competing versions came from managers and their allies. Ellis Hawley terms this view the business commonwealth. And this was Young and Swope from General Electric. They wanted a delegation of authority to management to run the economy free of product market competition. Think about that. Young and Swope had a clear-cut political profile as the advocate of this position, and Dodd was aligning himself with them. Okay? Young and Swope were not, however, in favor of sharing with constituents. They viewed employee security as a part of a kinder general employee relations model that they'd instituted at GE in the 20s that they thought would yield production efficiencies. Unfortunately, in the Depression-era economy, it wasn't yielding efficiencies, and they went into politics looking for government policies that would backstop their flagging business plan. The opposing corporatist model came from academics like Berle, the planners. They opposed an open delegation to management and wanted strict government oversight of the planning process. And unlike the managers, they wanted labor to get a place at the big, new national negotiating table. Berle must have gotten quite a jolt when Dodd took him to public task for having left labor out of the corporate law picture in the 1931 article. Dodd attacked the shareholder trust from the left, even as Berle stood to Dodd's left, and Dodd knew it. So, how to respond? Well, the book wasn't out yet, so why not answer with a preview of the Commonwealth Club speech? Well, that wasn't an option. FDR had not yet opted for the planners over the Brandeisians, so he couldn't do that. And gee, it's one thing to write a speech in September, and it's quite another to put out a law review article in June. So Berle's response, published in the next issue of the review, avoided any mention of ultimate policy goals and concentrated on what was wrong with the business commonwealth model. So they want to empower managers. Why empower managers when unbridled management power is the problem? Controls are necessary, and trust duties to shareholders are the only ones available, at least right now. And when we're finally getting around to addressing this problem in a serious way, which we would do in 100 days in 1933, lawyers like Berle would be better equipped to deal with the problem than managers like Young and Swope. So that's the response. It addresses only the situation a few months before the 1932 election and does not stand for shareholder primacy. Indeed, it puts shareholders in their place, according to political legitimacy only as passive recipients of wealth created, because as recipients, they to some extent represented the welfare of the general public. Later, Berle would add that full political legitimacy for the shareholder interest would only come when wealth was so widely distributed that the shareholder interest, in fact, proxied for the public interest. The shareholder primacy gloss came from Dodd as an accusation.
Moving on to Brett, Professor McDonnell.
So it's a little daunting following Bill. The article with Wachter that he's based on is probably the leading sort of modern law professor's take on the debates, or the most deep dive into the history of the debate. So I come away sort of half convinced, half not. Nonetheless, on that, I sort of come away thinking Dodd is still actually, at least as he stood in that article, as what he said in that article, is a pretty good precursor of the main thread of modern stakeholder approach. And I'll say why about that in a minute. I agree Berle is a more tricky figure, although even there I think there are elements of the modern shareholder primacy theory that you can see coming out of that paper, although he has many other many other things he stood for over his career. So first on Dodd, I see Dodd in that paper at least, as very much fitting the sort of managerial discretion version of the stakeholder approach, which is sort of the dominant one in place right now. The Business Roundtable, Marty Lipton, there's a lot in that piece that I think really Dodd sort of prefigures a lot of the main themes. So again, he's drawing on people like the GE folks, very much places emphasis, trust on those persons to come up with a way of running the businesses that'll be good for all the major constituencies, shareholders, employees, customers, the public good. And I think in developing that argument, he makes a few points that are still important and worthwhile in the stakeholder approach. So he has a story about, well, why should we trust them to do that? Well, the exercise of power, they'll become responsible to these groups through their interactions with them, and he thinks there's sort of development of an ethics model, which is, again, if you want to defend that version of stakeholderism, that's the kind of argument you need to make. And one other thing I'll point out about Dodd that is, I think, still useful and still ahead of a lot of discussions in the stakeholder approach. When you see stakeholders defending the position, there's a real ambiguity in what they mean. Are we talking about stakeholder interests because in the end, that's good for long-run shareholder profitability anyway, so there's no real contradiction in the long run, and it's kumbaya, and we can all get together? Or do you recognize that sometimes there are really conflicts between the interest of shareholders and some of the other major stakeholders, and sometimes you should be willing to make decisions that hurt the shareholders and help other groups? And Dodd sort of recognizes both of them and takes a bit of an middle position. He says, most of the time, indeed, the kumbaya is right. Most of the time, if we take this approach, it's going to be good for shareholders in the long run. There are some times it won't be, though, and you should be willing to make decisions that may not be best for shareholders in the long run. That still won't have a major negative effect on shareholders because in the long run, most of the time, it's going to be good for shareholders. I think it's a pretty good statement of the mainstream stakeholder approach, more or less as it applies today, though obviously there are a lot of institutional details that have changed since then. Berle's a more complicated figure, and I think your work has helped me learn a lot about how that article fits within the general. The way I take Berle, both in the 32 Harvard piece and in his other work, is his main challenge to Dodd isn't necessarily so much stakeholders versus shareholders, it's accountability versus non-accountability. Dodd's approach, as I say, is very much a focus on we'll trust the business leaders. And Berle's main response in that article is you can't trust them. If you just go like, they're free of the fiduciary duty constraint that I've talked about in this previous piece, you just can't trust them to make decisions that won't be in their interest or what they think is good as opposed to what's really good. So we need some kind of constraint, the fiduciary duty constraint, duty to shareholders is what. And that argument is still out there, right? That's still an argument that gets made all the time. If we have a stakeholder model, well then the duty is no constraint because you can always justify any action as helping some shareholders. So that argument, he sort of helps give rise to that argument. It does raise the question, odd for a new dealer, well, how do you protect other parties? And he doesn't really address that in the article at all. He just doesn't take that on that I can see. I just reread it as part of this, and I just don't see it. So I think from his career, though, you can take several ways of thinking about that, how you might try to answer that. One is he moves, in the end of his career, he moves towards the stakeholder approach of Dodd and says that Dodd was right, and Dodd won. But one thing you could see his position as evolving towards, as you answer that question, is the way the New Deal eventually evolved, especially post-World War II, as, well, what protects other stakeholders? Well, the market, if you believe that, but I don't think Berle would have believed that. But other forms of law, employment law for workers, consumer protection law for consumers, and so forth. That is sort of the way what he was doing in the New Deal eventually involved, and so that's one, and again, that has become the standard argument for shareholder primacy persons today. One thing interesting, again, in Bill's story, a sort of different version of how you take into account other interests is through this sort of public bargaining model where unions and business executives and the government are all sort of bargaining together over how the economy is going to be regulated. And I think especially the role of unions there is a sort of different way. Having unions involved as the protectors of employee interest is a different model you could have, and one that I think was very much a part of the New Deal thinking and looks has gone somewhat by the wayside with the death of unions. But is still another way you could go. Another thing that interests me, and I will lay my cards on my table, I'm a stakeholder mainly because I care about employees. Employees' involvement in corporate governance is what brought me into the interest in corporate governance. It's a very lonely position in the United States. If I were German, I'd have much more company. I'd be defending the status quo, but not here in the United States. Berle actually has a New Republic article in 1921 called How Labor Could Control that actually argues essentially for labor governance of businesses. Again, it's another way of accountability. So over his career, there's different potential approaches to how accountability could be achieved, and I think he's still learning that history. For me is a useful way of thinking of there were these other options out there. Both the shareholder and stakeholders' positions in our modern day have gotten to just one or two answers of that, but there were a lot of other options out there that Berle sort of toyed with over his life, and I think some of them are worth thinking about today.
Excellent. Yaron.
So, great. So, Bill and Brett already covered a lot of ground. I'm going to try to kind of take us a little bit into present day and kind of connect the historical debate to what we see today. And there's both similarities and differences that I want to kind of try to touch upon. So the first thing is, that debate was against the background is somewhat similar to what we see today. It's kind of, the New Deal, potential, the Great Recession. Basically, we have this public opinion that is kind of wants some sort of a transformation of the corporate world. And then this regulatory threat of potential intervention changes in how corporations can act and what they need to disclose to investors, which kind of happened in 1933-94. And we see a similar potential here too, right, with potential legislation that has been offered by Senator Warren, by public opinion that is putting more pressure on what companies should and should not do. So in that front, we really see striking similarities in the backdrop. But I think there are also big differences in what the landscape is as far as corporate governance, corporate law is. So if Berle and Means are kind of focusing on this, and Brett touched upon it, on the managerial agency costs. So shareholders are in their framework are almost powerless, and you need to kind of go and bat for them because they can't really protect themselves from managers doing whatever they want. The picture is a lot different today. Shareholders have much more say and power compared to what it has been even 10 years ago, and we see the rise of large institutional investors and their ability to influence corporations. We see hedge funds that are taking potentially strategically positions that are pro ESG moves, as we saw with engine number one. So it's becoming less and less about managers versus shareholders and more of a question of shareholders between themselves. Some of them are more pro-stakeholder and some of them maybe are less. Some of them are wearing two hats. Some of them are both stakeholders and shareholders. Some of them are just shareholders. Some of them are interested in short term. Some of them are interested in long term. And that kind of both complicates and transforms the debate from where Berle-Dodd had it on like the managerial agency cost to more of the shareholder stakeholder agency concern. And it also leads the question that then if we are transforming the position from whether managers should be prevented from exploiting shareholders to whether shareholders are allowed to exploit stakeholders, it also put the question of what shareholders actually do. And I just want to, put it out there that a lot of shareholders actually bring about stakeholder interest, right? So not always, and not always employees, but we see more and more that shareholders themselves are the driving force of a lot of stakeholder policies. But the engine number one campaign for fossil fuels, we see it with shareholder proposals on various topics that are put forward for corporations and actually gets significant support from shareholders, not just from stakeholders. So in a sense, there is some conflict, but it's also not always two sides of the aisle as it might be portrayed to be. I'll leave it at that.
Jill, you're the cleanup.
Okay, well, it's a great pleasure to be here. I really appreciate the invitation, and I so much appreciate being in an in-person event and seeing your faces. This is absolutely fantastic. Just, shout out to all of you for showing up. So I also want to draw the connection from the really great historical analysis that Bill and Brett gave us to the situation today. And I want to start off by just posing a few questions and maybe expanding on the questions that Brett raised about clarity, right? We have this term stakeholder governance and, Business Roundtable statement and Larry Fink's letters, and even the move, right, taking it one step further to try to persuade corporations to convert to public benefit corporations so that they can fully embrace stakeholder governance. So as Brett said, we have this whole public debate, but nobody really wants to drill down and commit to what they mean by stakeholder governance, right? A whole lot of the literature is in what Brett called this kumbaya world in which everybody wins. And, it's whether you think stakeholder governance is a tool for increasing shareholder value, maybe combating short-termism, or whether you think, well, it's not simply an instrumentalist, but we really can have it all. If you look at things like Viva's proxy statement, trying to get shareholders to vote in favor of converting to a PBC, what Viva said is converting to a public benefit corporation in which we embrace stakeholder governance is going to allow us to increase value for all stakeholders, including shareholders. Well, who could not be against that? But, it's a much harder case if we acknowledge that stakeholder capitalism might involve trade-offs. And here, right, I'm going to push even further than Brett. I don't think the trade-offs are just occasional or incidental, because if they are, why are we debating so much about stakeholder governance, right? What's really at stake if most of the time everybody's interests are going to be aligned? So we've got to think a little bit harder about what it means to embrace stakeholders. And here you have things like constituency statutes that say, okay, managers have the power to think about other stakeholders. That seems a little bit like what Dodd and Berle are writing about, this idea that this is something that should be or could be part of their job. But that's a little bit different from the obligation to commit to consider other stakeholders. And it's even more different from the obligation to promote or favor non-shareholder stakeholders. And here's where I think the rubber meets the road, right? How do you decide what is legitimate stakeholder governance? And at the end of the day, what I see a lot of is people saying, gee, if you hurt any possible stakeholder, you are not truly committed to stakeholder governance. So the criticisms of the CEOs who signed on to the Business Roundtable statement is, look, your company isn't sufficiently diverse, or your company is polluting, or your company did something that's bad for workers. Therefore, you are not committed to stakeholder governance in the way that you claimed when you signed that statement. And I kind of shake my head, I don't know. Which stakeholders are they supposed to promote? And can it really be the case that you have to be in this kind of Pareto optimal world in which every decision does no harm to anyone? But then I think about the flip situation. If Exxon says, we're doing a whole bunch in oil and gas and that's really bad for the environment, but we're promoting high-paying worker jobs, are they a stakeholder governance? Are they committed? Is that what the stakeholder, Brett, is that what you have in mind? I'm not sure. And I'm not suggesting that there are easy answers to any of these questions, and here's where I'm going to take it back to Berle-Dodd. If we don't know what the objective function is, then who decides becomes incredibly important, right? And where Berle-Dodd were weighing in is, should this be something that management decides? And, if so, how do we cabin that managerial discretion? Right? So shareholder primacy in those early debates was at least a potential tool for cabining that power. And as Bill notes, at the time, right, this management discretion wasn't really anti-regulation, right? So in those days, the idea of giving managers more discretion was so that they could work with government to promote the public interest. Today, stakeholder capitalism has taken on an entirely different meaning, right? Advocates of stakeholder capitalism view it as an alternative, a substitute for government failure, right? The government not stepping in. And then you have to ask the question, well, okay, so managers are going to do this on their own. They're going to do it without the constraints of the political process and political accountability. And how exactly do they solve this objective function problem? How do they decide whose interest to prioritize? Now, I'm going to wrap up in just 30 seconds, but here's where I want to bring in some of what Yaron said, right? Because what we see, Yaron said, well, the way managers are going to decide is we're going to have input from shareholders, right? Shareholders are actually taking the lead. They're going to help managers get to the right conclusion. Now, who are those shareholders? Who are the hedge funds and the mutual funds and the engine number one? These are not technically shareholders. These are intermediaries. These are people who are managing other people's money. And what you kind of worry about is you've got big asset managers who exercise a lot of power, but is it the preferences of Larry Fink? Or is it the preferences of the individual mom and pop 401k investors who entrust Larry Fink with their money? And so when you think about stakeholder governance, remember the Berle-Dodd debate was about accountability. The accountability questions that we are asking today look a lot different because of the development of these institutions. But at the end of the day, accountability in this area is really important. I'm going to stop there.
Thank you. And I'm going to follow up a little bit on what Jill said, because I think Jill has identified something quite important, and I want to go back to the panel on this, because I think the issue is much more deeper than Berle and Dodd. Berle means and Dodd. I mean, Lynn Stout and I used to debate this all the time. We were kind of the dog and pony show at an institutional shareholder conference. Oh, there they go. And finally, at one point I said, Lynn, this is a silly argument. I said, silly in the sense that I don't disagree with you. I said, where I disagree is, where fiduciary obligations go and on accountability. I said, every board always considers the other stakes in making a decision. It has to. If your employees don't like working for you, you've got a big problem. If your customers don't like shopping from you, buying from you, you've got a problem. You always have to take those into account. And I said, to suggest that it's one or the other, I don't think makes a lot of sense. And we kind of laughed about it. And I always wondered where this thing would end up, because at that point, primacy was sort of was the name of the game. Anyway, if you get down to it, the classic argument was that, and stakeholders, that corporations are part of society. As part of society, the obligations of a corporation isn't merely to those who invested in it, it's to everyone who's part of the group, so to speak, and hence the change. The downside to that approach was, your watch stops, it still gets the time right twice a day. Accountable to everyone, accountable to no one. Accountability issues, poor performance, everyone loses. Then it sort of, this argument evolved into performance, shareholder value, shareholder rights, and of course, if we did apportion the rights, or divide up the rights, if you will, between the stakes, you've taken something away from the shareholders, because you've got to switch from a primacy regime to a stakeholder regime. Do you have to compensate them for it? Probably not. What is the economic value of what they lost? And more importantly, they still have the vote, because if you say, okay, the stakes all have a role, they get votes too. How do you apportion the votes? And if you leave the votes in the hands of the shareholders, they're obviously going to elect people who favor them. But then it got a little more complicated, and this is, I think, going to be the nub of this debate, and I'm really interested in this panel. Berle and Means are great, and Dodd are a great starting point, but they're not the end debate, because I think the debate shifted. The terms are the same, stockholders versus shareholders. The difference, though, is in corporate purpose, and I think that's the more important point here. What's the point of a corporation? Oddly enough, historically, the debate was, I think, Brett, you're right, was labor. It was labor power versus managerial power versus shareholder power, worker capital versus labor capital versus capital capital. This debate is a bit different. Number one, unions own a lot of stock. Bizarrely, a lot of the value in a union today is in the financial value of their retirement funds, oddly enough. And for years, the greatest advocates of shareholder primacy were labor governance funds, labor funds. And it's interesting today, the greatest advocates of the stakeholder theory happen to be coming from the large institutional investors you would think would go the other way. And the question is, well, why is Larry think, what is Larry Fink's issue here? Why are the shareholders promoting something that are directly related to shareholder value, which they're supposed to be doing? And the answer is political. If you note, most of the discussions today have to do with ESG. And if you notice, G, the governance, comes last. I always thought the G should come first and the other two follow. But it's ES, environmental, social issues. And the crux of the argument today is corporations need to be greater social, political actors because the government has failed, shifting governmental responsibility in the area over to corporations. So what is the purpose of a corporation? It is to be an effective member of society, to promote political change or social change where society, the traditional institutions, have failed. And the question is, and A, what would Berle, Means, and Dodd think about that one? And B, what is our corporate purpose today? Is a corporation simply there to produce a product and return a good, fair product at a fair price and return profits to the investors? Or does it become an agent of society? And should it be? Is it appropriate as an agent of society? Because I think that's really what we're coming down to in this debate today. It's not so much labor versus management, because those lines have been blurred because of the ownership, changes in ownership, and the event of the 401k, and et cetera, et cetera, et cetera. But why have the corporation? As Larry Fink would suggest, the ES is critical, and not all of you've seen, but a lot of what you've seen from those institutions aren't governance changes anymore. They have to do with sort of social, political changes in the corporation, and that's what's coming from the CEOs as well, the stances they've been taking lately, and maybe there was inspiration to that in the Business Roundtable's retreat to stakeholder capitalism. But with that, I want to go to the panel. Is this new debate? Is it a good idea that a corporation involve itself in this process in this manner? Is that a correct approach? And what would old Merrick Dodd have thought? Bill, can I start with you, because you know more about Merrick Dodd and Berle than the rest of us.
So Merrick Dodd, once the Depression was over, Merrick Dodd rejected everything he said in 1932. Okay? In 1941, he took another look at it, and he said, we've got federal securities laws now. We've solved a lot of those problems. The emergency's over. I think we should just go back to where we were before 32 and have the corporation managed for the shareholders. Okay? That it was temporary.
Sort of the never mind.
Okay. It was like never mind. And he admitted, he said Berle was right. Berle, in 1954, said that Dodd had been right. No, he didn't say that. He never thought Dodd had been right in 1932. What he said was that now, after World War II, I look around, and managers are doing their job with the public's interest in mind. This is 1950s, 60s managerialism, okay? The post-New Deal national political settlement. In that context, Berle looked at management, and management prior to the 1970s was very, very decorous about getting in the government's face. The New Deal state was still there, and management played a very careful game through its lawyers and didn't rouse the state. Berle built a whole post-war political economy on that picture of cooperative, this was all implicit. The state was empowered, managers cooperated, and everything's working well. Don't touch it, okay? People are happy with this new arrangement. Berle looked at that post-war equilibrium and said, that's pretty much what Dodd had been talking about in 32, but what was missing before the 100 days was an empowered state. Now that we have an empowered state that cows management and implicitly gets them to cooperate, we have realized the vision that Dodd was pursuing in 32, but what Dodd missed was that you have to have a big state in there or it's not going to work. Okay? That's a political economy that just rolls over and dies starting in the 70s. Berle's remembered, and Brett's absolutely right about this. Berle's remembered because he made management accountability a problem. Separation of ownership control means unaccountable managers. Okay? Everything else that he was talking about is forgotten. Okay, and that's absolutely correct. That's the reason the BerleDodd debate is still read.
Interesting. Your all's reaction to it. Brett, what do you think?
So
Political,
I go
labor
back and
political, or something
forth.
different?
I mean, there's this whole sort of handbook on corporate purposes, both among academics and in real life. It's a huge deal right now. And I go back and forth on how much corporate purpose really matters. I think it matters somewhat, but I don't know that it matters all that much. And here's my skepticism. If you take a broad stakeholders approach, as I said, and I think Jill you can justify just about anything with that. It doesn't really constrain you much. If you take the traditional shareholder primacy approach, though, when you combine that with the business judgment rule, you can again set aside, sale of control, where it does have a bit more bite there, but set aside that. Again, if you're just a little more ingenious, you can justify just about anything, right? So but it does come. Its main impact, I think, is rhetorical. If you're on the shareholder primacy model, you have to justify it ultimately and say, oh, we're helping the employees, but ultimately we'll get better employees, yada yada yada. Whatever stakeholder you're using to justify it, then you have your built-in why that's tied to long-term profitability, and now you've gotten there too. Now I do think the rhetoric matters. Rhetoric matters in terms of setting norms within corporations and norms across corporations. So maybe it matters for norms. And I'm interested in what you think, Chuck. I mean, if it's one or the other, you don't, I assume, think you're going to be sued if you don't, because you can always say the right thing, even if you're in Delaware and it's a shareholder primacy model. You're going to always be able to justify what you say, but does it affect your sense of norms of what you should be doing? There, maybe it does matter. But if there's a way it matters, I think that's mostly how it matters, again, outside of share of control, which is why I'm, in the end, more concerned, not with purpose, but with actual governance and power. And again, I'm an employee person, so my one is employee power in actual governance. I want Germany. And that would make a real difference. If businesses are worried about the Accountable Capitalism Act, it shouldn't be the purpose part of that worries them. It should be the employee director part that worries them.
Well, it was very successful at Volkswagen.
Hey, Charles, give me a minute to answer your question, which I forgot to do. Okay, 1 minute. I think I agree with Brett that the legal statement of corporate purpose always must equivocate. And we're talking about norm generation at a different level here. Okay? And what's going on right now is very interesting, and I think it's new.
Well, Bill, I think it's very different. I think the idea of the corporation as a political actor is very different than it would have been 20 years ago. I mean, corporations, traditionally did get involved in the political process, but it had to do with their basic interests. The oil companies, legislating against environmental reform, lobbying against environmental reform, et cetera, et cetera. Today, there seems to be an agreement of a broader purpose of the corporation. That's the Larry Fink letter, which is to me, that's the most extraordinary thing of them all. A, who elected him? Sorry. B, why is the owner, whose obligation is to return profits to his investors, suddenly saying maybe they're not as important as these broader issues, or I don't think monetary value of the corporation is as important as societal goodness. That's a weird turn of events if you think about it. And the bigger question for him is, will his investors necessarily agree with him? And is he making it more difficult for people to invest with him or other large index funds if that's the case, because it's divisive? The danger, I think, on tone, Brad, I think you make a good point, is that I think tone is important. Because if the tone of the organization, let's say, anytime a company, let's say, takes a political position, you're going to, in this divided country, you're going to anger half of your constituents, one way or the other. So, and I think that a company business, to be successful, has to move with near unanimity of purpose. And you throw something to the mix, it's very emotional. That's why, by the way, you'd never have political conversations at Thanksgiving dinner. They're disastrous. Don't do it. And I think the same thing applies to, certainly I've seen it in boardrooms. It really divides people up. And you lose the focus of the enterprise itself, despite your view of how good your position is. And obviously you think your position is right or you wouldn't take it. Problem is there are other folks who may not agree with you. By the way, that's why law professors get along so well, because we all know we never agree with each other. That's why we're in business. Anyway, but I do think it's important, and I think it sets the tone. Unless the tone is correct, the underlying governance or operation is problematic. Why do you have these rules? The rules are sent us to a particular direction. When I teach, shareholder primacy, I said to understand government, you got to start to who are the obligations run, because your rules are designed around a particular system, and if you can't figure for what purpose is it, the rules will make no sense to you, much like bureaucracies operate. Yaron, what do you think on all this?
Yeah, so first I'll just piggy off on what Brett mentioned about norms and stated goals. I think rhetoric does matter a lot. It's true that you can probably get to where you want to go with both types of corporate purpose versions, but when you talk to directors, and I think a lot of directors, when they get into the boardroom, they want to know what their objective function is, and they will let it influence them. And having a statement that they should, prioritize also other stakeholders' interests will make a difference, just in the way they go about thinking about stuff. And I think it will also, and when we see it with academic studies, but it will be coming from investors too, accountability. If a corporation states that its purpose is to also promote employees' welfare, and it doesn't is not doing it, they will be held accountable by investors as well, especially those investors who might have chosen to invest in that corporation because of that statement of purpose. And all of us probably teach Ford versus George. That case is an example where your state objective might he decided to kind of explicitly take this corporate purpose, although he probably had a shareholder motive behind it, which is kind of like a flip, but sometimes it can get you in trouble. On the point of what you asked, Charles, about is this a good idea to have the corporation involved, from a realistic perspective, I don't think you have a choice. I think corporations have become more and more intertwined with society. Some of them are actually, forming societal views. We have mega corporations who are involved with all kinds of things, and you see shareholders get involved. They understand that you have the safety valve that they can get input there, and they do it. So, as a practical matter, even if corporations should be left out, they are not going to be left out. So then the question for me is, who's going to be in the best position to make decisions about what the corporation should and shouldn't do? And as I kind of indicated earlier, I think for the time being, shareholders are the best in the best position to do it, and they are in the best position to do it because they are kind of having a mix of motives, right? Some of them are also stakeholders in interest. Some of them have the externalization the corporation will have also impact them, right? So global warming and issues like that is stuff that shareholders care about, not just because they invest in the corporation, because they live in the world. and so on and so forth. So my view is that I'm worried about trying to shift too much into kind of like a central government or kind of stakeholder regime, not because it might, it's not, intrinsically it's bad, but because shareholders right now are showing us that they can, for the most part, do it, and just incremental moving is probably more wise at this point.
Jill?
So you asked whether corporations should have a purpose, and I can't figure out what a purpose is or what it means for a corporation to have a purpose. And yeah, I know that that's part of the ALI restatement. I still can't figure out what it means. So far as I can tell, it's a response to what Brett said. Rhetoric is powerful. And there are lots of people who want to buy in, right? We've got all of these millennials who want to work for a company that has a purpose that, resonates with them, they agree with, right? Some of you are millennials, you feel that way. I'm not a millennial, so I can just say that, those guys. But, we've got politically active people who want the corporation, want these big, powerful people to make a statement. And in fact, it's more, right? It's not just we want corporations to be involved, but we denounce corporations for sitting on the sidelines, for not weighing in on every politically, socially charged issue, like voting rights and diversity, right? How can you not have a statement in the Wall Street Journal saying you are pro or against whatever it is? At the same time, do we really think that that's what corporations are about? Because the word purpose suggests to me, this is what you do. I think of the most sort of socially oriented corporation, at least, that I focus on in teaching, and that's Ben & Jerry's, right? And, Ben & Jerry's, we all associate Ben & Jerry's with saving the rainforest, and they were really committed and everything like that. But was Ben & Jerry's purpose to save the rainforests or to sell ice cream, right? And, at the end of the day, right, if you want to organize a nonprofit to save the rainforests and you want to sell ice cream to do it, you can. And then you don't have to worry about shareholder primacy, right? So we have a choice in the way we, try to promote social change. And I'm not saying that social change is bad. I'm just not entirely clear how it fits into being a productive member of society and manufacturing and selling, goods and services and all of those other good things that corporations do.
Well, the point of corporations is to provide a product.
I associate Ben & Jerry's with additional pollution in the Vermont countryside.
There you go.
I associate with Cherry Garcia, personally. But, it's funny that all this talk of political and social involvement takes me back, about 20-some-odd years ago. I was on the board of a consumer products company. You remember the big Made in America movement. You buy American, made America, buy American, made in America. And we sold toasters and blenders and things like that. And we were made in America, but we got into big trouble. People stopped buying our products. Why? Because they were more expensive than the products made other places, not made in America. And it always surprised me, like, we're made in America. So what? In the end, when the rubber hit the road, and you have so many dollars in your pocket, and you need a good or service, you need a new toaster or a blender, you're going to buy the cheapest blender that happens to work. If it doesn't work, you're not going to buy it. So we always said we're quality, innovation. I mean, how do you innovate a toaster, right? But the idea was that ultimately people buy goods and services that they need. And the social or political tend to fade a bit as you get down to the sort of basics of life. And it's changed my view of what the corporation should do or can do. Should it be doing it? Because that's the unity of purpose. If you don't get everyone to agree who's working there that this is what we do, you're never going to. Your cooperation equals ultimately profitability and success. People want to kill each other over a particular issue. That's never helpful. But ultimately, the public that you serve is a little double, has a bit of a double view on this. It's the old joke, I don't care what I earn, but I care very much about what other people earn. which goes back to you. In other words, when it comes to you, you're a little different ultimately, even though you may espouse a particular position. As I said, rubber hits the road. I want to ask the panel before we go to the audience, because I think this is an important question on this. With this, with this sort of stakeholder movement, the bankruptcy system was developed with the notion of shareholders come last, right? They're always last. They get a vote. That's why they come last. In exchange for being last, they get the vote and they get fiduciary duties, more or less. If we change that scheme, what happens? Do we change bankruptcy? And do we have to change, ultimately, voting? Does voting change? And is voting dispersed amongst all the stakes? Can it be? Should it be? And should shareholders from now on come last? And does that ultimately result in shareholders no longer being shareholders, but shareholders instead contributing capital in the form of debt, which obviously is problematic for a new business? It's a mouthful, but I'm kind of curious. It's called making a point and asking a question, too. Who wants to grab that?
The
Brett?
shareholders only recently in history started to come in last in bankruptcy in this country. That's a new thing. The statute never said that, but that's not how it worked out. Okay, and you're worried about that?
Oh, not worried at all. I'm worried in a stakeholder regime. One of the exchanges that a shareholder got for the shareholder primacy, because they're last in the end, means they have to protect their interests much more fiercely in the other world before they go to the underworld of bankruptcy.
Oh, okay. Well, on that, I always go back to the moment we had about 10 years ago when, after the hedge funds came in, and we woke up one day, and it seemed like the separation of ownership and control was no longer corporate law's great unsolved problem, because the shareholders could now protect themselves. Okay, and I think what you're talking about is the piece of the shareholder primacy argument that says of all the constituents, the shareholders as the marginal interest holders are the weakest.
Correct.
Okay.
Which is why they had the vote.
Therefore, deserving and in need of our solicitude. Okay. And I think the picture on the ground has changed as to that in the last decade, and that we need to rethink the place of shareholder helplessness in our working picture of corporate governance.
Does that mean we reallocate voting rights?
No, I think it's appropriate for the shareholders to get wiped out in Chapter 11, and they're pretty much in the driver's seat before we get there.
Brett, what do you think?
So I'm going to punt on bankruptcy because I haven't thought about that, and it's not obvious to me what I don't think it would change my approach to bankruptcy, but I'm not a bankruptcy scholar, so I'm going. But as I've sort of alluded to several times, in terms of basic voting rights, I would reallocate. Now, I'm not sure I would actually force this on all companies. I would give inducements to them. I'd give them tax breaks or give them breaks in employment law. I have a paper upcoming with Matt Bodie on this. If you have employee governance of various types, you can get more lenient treatment in employment law. But I would allocate some voting authority to employees, but only employees among the state. I think we talk about stakeholders like all these different groups, but I think employees are differently placed from all the other major stakeholder groups. They're more internal to the company, insofar as you have this residual claimant argument that Bill makes for the shareholders, that in many ways employees, at least with a longer term stake in, plan to be in the business longer term, are residual claimants as well. They are able to contribute more to corporate governance than most stakeholders because they know what's going on. So but I think employees are different from all the other stakeholders.
Of course, the other stakes may disagree with you, but Yaron, what do you think?
Well, it's an interesting question. You focused on the voting rights, but there's also a question of priority in bankruptcy too, right?
Well, your last in priority.
Well, so if you take the voting rights, you might want to rethink the priority. I think, practically speaking, on bankruptcy, and I'm not a bankruptcy expert, but the sophisticated shareholders are often able to kind of maneuver themselves in a way that allows them to not be last anyway.
They buy a lot of debt cheap.
They buy convertible debt, or they are hedge funds have done well in bankruptcy. So that paradigm is somewhat ancient anyway. I would just say that again, even in a stakeholder model, I don't see it changes dramatically the need for shareholders to be the original claimants and kind of with the voting powers. We're talking about maybe the corporation trying to kind of think about employees more, making some sacrifices, but we're not talking about a world where it's clear the corporation, the utility is just to make sure that every employee has like a wage and nothing more, right? You still want to create some value for some group. So I don't know if it will undermine the whole theoretical underpinning of why we have voting rights for shareholders and why they potentially go back to the end of the line when we go to bankruptcy. But both of them are actually challenged in practice, right? Voting rights, stakeholders get to vote. They get to vote because they buy shares, and they might have an interest that is not aligned with shareholders, and shareholders get not to be last because they can manipulate the bankruptcy system maybe as well as anybody else.
Right, and that's Jill, before I go to the audience.
Yeah, so I'm not a bankruptcy scholar either, but the little I've read does lead me to think that Yaron is right, that shareholders, even though technically they're supposed to come last in bankruptcy, they don't necessarily, at least all of the time. On the voting question, I think the practicality of setting up some sort of system with stakeholder voting, right? Brett, you finesse it very nicely by saying, well, it's just employees. Mm-hmm. But, if we take stakeholder governance seriously, who votes to protect the environment, and people's views about how much to protect the environment vary, and customers and customer voting, and what about creditors? And, creditors, corporate law has for a long time had the capacity to at least allow creditors to vote. Why don't any corporations allow creditors to vote as a matter of course? Probably because it doesn't work so well to have multiple groups represented in the voting process. So I'm not really sure how you do that. And just the last, sort of flipping it around, it's never been entirely clear to me that shareholder voting made a lot of sense. And certainly if you go back, we started teaching many years ago, and shareholder voting, if you go back to like the 1980s, wasn't all that important.
No,
you didn't have a whole lot of institutional investors. The investors you had didn't really exercise their voting rights. They certainly didn't challenge management. But at the end of the day, if you don't have shareholder voting, it leaves you with a lot of questions about, well, how exactly do you govern these things, and where does a board get its legitimacy from? So I'm not sure that I'm making the affirmative case, yes, shareholder voting is great, it's the right answer. But, it seems to me the alternatives, at least right now, are kind of hard to work through practically.
Winston Churchill said that democracy could be the worst form of political organization, but no one's ever come up with a better idea, so to speak. All right, questions? Sorry, go ahead.
Hi, good
We're ready.
morning.
Okay, we're ready.
Good morning. Thank you for a very interesting discussion. I want to ask Professor Fisch to elaborate on one of your points. My perception is that in many cases, corporate management is in fact responding to shareholder pressure. Now, they may enjoy doing so because their values as part of the circle in which they live, work, eat, breathe are the same as the people who manage those shareholders. So they may be glad to do so. But ultimately, I think they're responding to shareholder pressure. The question I have is those shareholders, or as you put them, the purported shareholders, what are the instruments to keep them accountable to their own shareholders? If you are an institutional investor and you've aggregated all this capital, you owe duties to the people who gave you that capital. What is the measure to make sure that it is, in fact, their interests that are being protected by the manager? Are they working the way they should? Is it different in a hedge fund where you can tell 6 or 12 of your best friends, don't invest in this for profit, invest so we can change the world, and they all sign up and say, sure, that's great, I'm going to take no or less return. But in larger circumstances, I think that's the next battlefront. When the investment managers have to look behind them and say, I'm now under pressure from my shareholders, how do I defend what I'm doing? I think you touched on it most directly, Professor Fisch. I wonder what your thoughts are.
Yeah, it's a great question. It's another hard question, and I think we're at this point just starting to look at the extent to which that's an issue. With respect to publicly facing asset managers, we do have disclosure, and the SEC, I think, just said it was going to have some sort of hearing where it looks at mutual fund disclosures of how they vote on, say, on pay issues, which, you know, goes exactly to your point. If the disclosure is inadequate, certainly investors can't impose some sort of check. But I actually see huge increase in disclosure about what the mutual funds are doing. For many mutual fund companies, you can go online and figure out exactly how they voted on everything, and they've simplified it beyond what the SEC's required in Edgar filings. So the stuff is there. The harder question is, well, what do the beneficial owners do to check that process? And, that's a really tough question, right? The DOL tried to weigh into that with its rule on, ESG, and, that kind of didn't perhaps work all that well or make a whole lot of sense. A lot of times, you also can't rely on market forces because the ultimate beneficial owners, either don't want to take the time to use the disclosure tools that are available, or they're investing through something like a 401k plan in which they have limited choices. I don't know the answer, but I think that's an important thing from a policy perspective that we should be looking at.
Can I ask a brief follow-up? It sounds, for all the world, like a collective action problem for the beneficial owners. What tools do we have that have been used in the past to solve collective action problems that might be of use in this context, do you think?
So, yeah, you could have pass-through voting, you could have beneficial owners set the preferences or direct the asset managers how to vote, right? There are a bunch of things that you could do, obviously.
Okay. Thank you.
Tough in an index.
But ironically, they're subject to the same problem that individual shareholders used to have in corporate governance.
Yeah.
Burley mean, you each have such a small stake that it's probably not worth it to you.
Agency problems involving the agent.
Right.
Clearly, we're back to classic principles of agency, and agency principal relationships,
Obviously,
which
it
are
depends on
messed
the
up.
fund, but for a mutual fund that's really, many investors.
But there are technological
Yeah.
innovations. Broadridge is looking at some of this stuff. There are a couple of private market providers that are, trying to come up with ways for harnessing.
But they still have to use that, right?
Yes.
Like, it's like the old wastebasket, right? Like, yeah, you can send them their vote, but most of them aren't going to take the time to actually vote on that.
So 2 points, because I actually looked at it, and there are ways you can nudge investors at least to have a default choice whether they want to be heard or not. With technology today, you can have a pop-up where you go and set up your 401k. You will have to make a couple of predetermined choices that basically will show general preferences. So there's ways to account for it. I just want to maybe make some sort of a distinction. It's important to know that institutional investors exert power in 2 different ways: one behind the scenes through engagement, and one through voting. I would be more concerned about the engagement because as far as voting goes, even BlackRock or the largest ones cannot change corporate policy alone, right? There needs to be somebody that puts the proposal on the table. That's not them usually, it's somebody else. Then you need enough investors to kind of support it to get to a threshold where management say, you know what, enough of our shareholders are really interested in that will actually act upon it. But the engagement behind the scenes, that's something that large institutional investors can actually push companies to do stuff even without asking for shareholder input, and that's a different story.
Excellent. Next question. Yes, sir. And when our Federalist Society hosts say, it's time for lunch, it's time for lunch. Go ahead, please. Yeah, please, go ahead, ask your question, please.
Professor Elson, you mentioned the 1997 Caremark conference. I know Professor McDonnell, he has a new article on green boardrooms where he talks about this a bit, and refers to serious obstacles surrounding this. I'm just curious to hear kind of your thoughts in a Caremark context from each of you in terms of possibilities.
You want to start with that?
Yeah, I'll start. So the question there, Caremark has this duty to make sure you're sort of that your employees, your business is not violating applicable legal rules, and some people, and more in other countries than the U.S., especially Australia, are trying to use that to go after boards of companies that are engaged in, in climate change, that are not mitigating climate change the way they should be under their laws, and would that work? And the tradition in the in Delaware, the Caremark cases, there is this notional duty, but the traditional notion was it was almost impossible. It was the hardest kind of case to win. There's still a norms-setting element to that, so I think the norms, my theory on Caremark was always it's mainly about norms. There have been these cases in the last few years, and I'm teaching these cases now, and I'm talking to my students, where all of a sudden, at least at the early stage, the motion to dismiss stage, those cases are being allowed to go through, which gives them a lot more bargaining power. And it's interesting to watch if there's a real change in the law going on there or not.
Do you have a sense of what happens after motion to dismiss in these cases?
Yeah, they were all motion. It started with Bluebell. Bluebell was the first, and then it's migrated. You've had a couple since, and then most recently Boeing. The theory basically is, in addition to establishing that you have a compliance process, the directors have the requirement, the duty to oversee the requirement process, which suggests that are they the insurers of the process, or merely those that ensure that the process exists? In other words, is it a duty to have it there, or are you supposed to get into the bowels of the process itself? Well, that's how one group reads the Supreme Court's opinion that was written by Justice Strine, Chief Justice Strine. Others may take a different view. I can't. I'm on an SLC for Bluebell, so we're actually in the middle of all this right now. Learn a lot about. We make ice cream, by the way, like Ben and Jerry's, but we're not Ben and Jerry's. I think we're better, frankly. I think cherry vanilla is much better than cherry Garcia. But anyway,
You're gonna make us hungry. and we're
Are they
gonna be
large
stopping at lunch.
settlements?
What?
Are they large settlements? Do you know once on these cases have gotten through these?
That's a good. Ours hasn't. There was a partial settlement in ours that was announced, and it was pretty big, but that was a different case. It wasn't the actual Caremark case. It was another slug. But we'll have to see. I mean, the other ones are still. I think Boeing is being appealed, so I don't know where that's going, and I don't know what happened to the other ones. There was one involving was it Bergen? What do you call it? The pharmaceutical maker had made the cancer drug outside of Philadelphia. Bergen something, or no, Brunswick Bergen, I believe. Was it Brunswick? Anyway, we'll see. Yes, sir, next.
Yes, I have a question about universal ownership theory. So essentially the theory goes that asset managers like BlackRock, instead of being primarily concerned with alpha or outperforming the market, are more concerned with beta, because most of their portfolio returns come not from whether they select stocks that do better than the market, but rather from the overall health of the market. Hence, they focus on ESG because the thought is that that's actually going to promote better market-wide performance and therefore better portfolio outcomes. So if that is indeed the case, and that's replaced modern portfolio theory, would that not suggest that some of these asset managers might be artificially repressing economic output and hence causing consumer harm, and perhaps raising antitrust concerns?
Or antitrust, or majority, controlling shareholder versus minority shareholders, because everyone isn't indexed, right? And if you quote are creating a broader societal move that benefits you as owning everything, you've just harmed someone who maybe owns something specific. I mean, you're going after portfolio managers, right, who invest in specific companies, or boards that are required to take the interests of specific companies in mind as opposed to the world in general, which I think would be a really interesting minority, courts protect minority shareholders. Your fiduciary obligation as a director is to every shareholder. I only respond to the index funds. That's silly, and it also puts you in a very bad legal position. I don't know. What do y'all think?
It's also really hard. So this idea of I'm going to do things that benefit my whole portfolio takes me back to Brett's statement about rhetoric being powerful. I don't know exactly how an asset manager goes about making those judgments. I mean, where you hear it most is with respect to environmental issues and the idea that, there's these environmental costs that create negative externalities for the other companies in the portfolio. But I don't know how an asset manager goes about deciding, gee, for this specific company, This is the level of carbon neutrality or carbon negativity or whatever that's going to have the right impact on my other company out there. And also, from a portfolio perspective, that isn't outweighed by things like jobs or consumer interests. I mean, you know, we typically have said that one of the reasons we don't give shareholders too much operational power is because operational decisions are hard and shareholders don't have the expertise. And now you want them not just to come in and decide what ExxonMobil should do with respect to emissions at ExxonMobil, but you want them to do this, you know, thousands of companies' portfolio-wide analysis. I mean, I don't have a whole lot of confidence. You know, it sounds like a good story, but I don't have a whole lot of confidence in their ability to get it right.
I think we just got the hook for the lunch break. By the way, everyone who's getting CLE, you got to take this card, is that it, and turn it in or check it. I don't know. I don't get CLE anymore.
QR code that you can put in or take a picture of on your phone. If you're here for CLE, just pick up one of these cards, take a picture of the QR code, and you'll be signed in. If your state... I didn't think I did anything. Your state might require a sign-out process as well. I think that works for it, but if your state does require that, come let me know. And if that QR code doesn't work, we can figure it out. Lunch will be served in the next room over, I believe, so we can make our way out. We're going to make our way back to this room about 1:15. We'll get started with panel 2. So thank you all for joining us again. And enjoy the lunch.
And thank the panel. These guys did a great job.